Your lordships have
Yes.
PDF page or the physical file, my lord. I can accordingly. The PDF page is 94. Para 166, my lord. जब मैं आऊं तभी जब वहां पे पहुंचू तभी Lord, the question is whether the governor is bound by act, aid and advice of the Council of Ministers, my lord. Lord, 163 I have read, my lord. I'll read the first part, 163(1), so that, my lord, for just immediate reference, there shall be a council of ministers with the chief minister at the head to aid and advise the governor in exercise of his functions, except insofar as he is by or under this constitution required to exercise his discretion or any of them in his discretion. Correct, my lords? So functions can be discretional, based on discretion, or as per aid and advice. My lord, what is the demarcation? That is the question, my lord, before your lordships, my lord. My lord, here, minimum, my lord, I'll skip what is not relevant, but the minimum Constituent Assembly debate, my lord, which is relevant for your lordships to consider the question, my lord, is at page 187, bottom. Lord, Mr. Kamath objected this discretion and it was answered by Mahavir Tyagi. Lord, please have a look at Mr. Kamath's objection. When you, sir, raised a very important issue the other day, Dr. Ambedkar clarified this clause by saying that the president is bound to accept the advice of his ministers in exercise of all his functions. But here, Article 143 vests certain discretionary powers in the governor. And to me, it seems that even as it was bad enough. But now, after having amended Article 131 regarding election of the governor and accepted nominated governors, it would be wrong in principle and contrary to tenets of principle of constitutional government, which you are going to build up in this country. It would be wrong, I say, to invest a governor with these additional powers, namely discretionary powers. I feel that no departure from the principle of constitutional government should be favored except for reasons of emergency, and these discretionary powers must be done away with. I hope this amendment of mine will commend itself to the House. Then, my lord, this argument is responded to by Sri Mahavir Tyagi, lord, which is here. I beg to differ from my honorable radical friends, Mr. Kamath and Professor Shibbanlal Saxena. And I think the more powers are given to provinces, the stiffer must be the guardianship and control of the central in the exercise of those powers. That, in my view, we have now given up the idea, the old idea of creating autonomous states, and are now keeping a reserve of powers in the center, and we are going to have nominated governors. Those governors are not to be there for nothing. After all, we have to see that the policy of the center is carried out. We have to keep the state linked together, and the governor is the agent, or rather, he is the agency which will press for and guard the central policy. In fact, our previous conception has now been changed altogether. The whole body politic of a country is affected and influenced by the policy of the center. Take, for instance, subjects like defense involving questions of peace or war, of a relationship with foreign countries, of our commercial relations, exports and imports. All these are subjects which affect the whole body politic, and the provinces cannot remain unaffected. They cannot be let free of the policy of the center. The policy which is evoked in the center should be followed by all the states, and if the governors were to be in the hands of provincial ministries, then there will be various policies in various provinces, and the policy of each province shall be as unstable as the ministry. For there would be ministries of various types having different party levels and different programs to follow. Their policies must differ from one another. It will therefore be all the more necessary that there must be coordination of programs and policies between the state and the central government. The governor, being the agency of the center, is the only guarantee to integrate various provinces or the states. The central government also expresses its thought, itself, through the provincial states. Along with their own administration, they have also to function on behalf of the central government. A governor shall act as the agency of the center, and we'll see that central policy is sincerely carried out. Therefore, the governor's discretionary power should not be interfered with. Democratic trends are like a wild beast. Say what you will. Democracy goes by the whims and fancies of parties and the masses. There must be some such machinery which will keep this wild beast under control. I do not deprecate democracy. Democracy must have its way, but do not let it degenerate into chaos. Moreover, the state governments may not be quite consistent in their own policies. Governments may change after months or years. With them will change their policies. The governors may change too, but the policy and instructions given by the center to the governors will remain practically unchanged. The more the powers given to the states, the more vigilant must be the control. The governor must remain as the guardian of the central policy on one side and constitution on the other. His powers, therefore, should not be interfered with. He is not for nothing. He is not just a showpiece. My lord, thereafter, your lordships may kindly turn the page, my lord. Pandit Thakur Das Bhargav, my lord, continues the discussion. Sir, I beg to propose the amendment of Mr. oppose the amendment of Mr. Kamath. Under Article 143, the governor shall be and in the exercise of his functions by the Council of Ministers. It is clear so far. कुछ कट गया मेरा. Article 143, governor shall be aided in the exercise of his functions by a council of ministers. It is clear so far. I gave notice of an amendment which appears on the order page at so and so, which I have not moved. In that amendment, I have suggested that the governor will be bound to accept the advice of his ministers on all matters except those which are under this constitution required to be exercised by him in his discretion. My submission is that it is wrong to say that governor shall be a dummy or an automation. As a matter of fact, according to me, the governor shall exercise very wide powers and very significant powers too. If we look at Article 144, it says the governor's ministers shall be appointed by him and shall hold office during his pleasure. So he has the power to appoint his ministers, but when the ministers are not in existence, who shall advise him in discharge of his functions? There can be a vacuum. One ministry goes, another has not been installed. In that context,
whenever there is a president's rule,
yes,
there are advisors to the governor.
Correct, they're appointed by the center. But can we read further?
In the vacuum also, normally if one CM resigns, or if he loses a majority till the new CM takes, he acts as a caretaker chief minister.
No, sir. Kindly, my lord, have a look at this one. Suppose, my lord, the tenure has gone. The governor tenure doesn't go. The new election takes place. It is considered, my lord. And it is considered subsequently in judgments also. My lord, 7-judge judgment, my lord, considers this aspect. Then again, when the governor calls upon the leader of a party for the choice of ministers after a previous ministry has been dissolved, in that case, there will be no ministry in existence, and who will be there to advise him? Therefore, he will be exercising his functions in his discretion. It is wrong to assume that the governor will not be charged with any function which he will exercise in his discretion. Article 175 and 188 are other articles which give him certain function which he has to exercise in his discretion. That is Article 200, my lords. And 188 is emergency powers. My submission is that, according to me, the governor shall be a guide, philosopher, and friend of the ministry as well as people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions, and some will be such as will be expressly conferred by this constitution. He will be a man above party, and he will look at the ministry and government from a detached standpoint. He will be able to influence the ministers and members of the legislature in such a manner that the administration will run smoothly. In fact, to say that a person like him is a mere dummy, an automation, or a dignitary without powers is perfectly wrong. It is quite right that so far as our conception of a constitutional governor goes, he will have to accept the advice of his ministers in many matters. But there are many other matters in which the advice will neither be available, nor will be bound, nor will he be bound to accept that advice. My lord, thereafter, my lord, Dr. Ambedkar's speech, which I have read, my lord, in a different context. So, my lord, I am not reading it here, but he, my lord, substantially echoes the Mahavir Tyagi view and the view of Pandit Thakur Das. Now, my lords, may kindly come to Lord, I have quoted Sirvai, my lord. If your lordships can come to, I will not read it. Page 192. My lord, what are the discretionary powers of the governor and the president? My lord, Sirvai has, my lord, H.M. Sirvai has elaborately dealt with, my lord. I may not read it. Your lordships may kindly read it. It would, my lord, really assist your lordships. Now, please come to, my lord, 194. Lord, these are the judgments on the question of discretion. Lord, please see 188 at the foot of page 194. It is, your lordship gets that? It is 194.
What?
194. PDF is 101. Para 188. It is submitted that this honorable court has carved out an exception to the general rule of the aid and advice, which is not expressly stated in the Constitution, however, which is in consonance with the intent of framers of the Constitution of India and also with the scheme of functions and powers of governor provided therein. A reading of the judgments discussed below and other provisions of the Constitution of India would show that inter alia, the following are the exceptions to the general rule of aid and advice, where the Constitution expressly provides for the same. For example, Article so-and-so, 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 where he will not be bound by the aid and advice, and there cannot be any dispute. These are constitutional mandates. B, where the legislative intent emerging from the interpretation of any provision of the Constitution, like the powers under Article 200, 356, or the power to dismiss the government which has lost confidence but refuses to quit, as has been mentioned in the report of Justice M.M. Punchi Commission, and have been concurred by a 5-judge bench of this honorable court in Nabam Rabia. I'll read, my lord, very illuminating paragraph of Nabam Rabia, where the constitutional courts specifically declare that certain functions ought to be exercised by the governors on his own. My lord, your lordships have developed this law, my lord, by judicial decision making. Power to summon or prorogue the House of Legislative Assembly under Article 174 when there are strong reasons and material to show that incumbent Chief Minister and his Council of Ministers seem to have lost the majority of the House. Then situations or matters where the bias is inherent in the aid and advice of Council of Ministers, like the case of grant of sanction for prosecution of Council of Ministers. 197 sanction or Section 17 PC Act goes before the governor, my lord, in case of Chief Minister, then obviously he would not be guided by the aid and advice, and MP judgment, my lord, I'll show that makes it very clear. Now your lordships may kindly see, my lord. This is, my lord, Lord, I'll skip that judgment. Please come to 197, Samsher Singh. Samsher Singh, my lord, is a 7-judge bench judgment. At the outset, I may point out that Samsher Singh 7-judge bench judgment is taken note of in state of Punjab versus Union of India, but the relevant paragraphs appears to have missed. It doesn't take care of the relevant paragraphs. I can, my lord, make that statement, my lord. If it is challenged, my lord, we can show it from the. It's not there, my lord. I can't, my lord. In state of Punjab versus Union of India, the 3-judge bench, my lord, 2024 judgment takes note of Samsher Singh, but it has escaped the attention of the bench of these 2 paragraphs, which, according to me, is the real law of the. Lord, your lordships would find, my lord, that judgment at page 11669. Just put a note, my lord. That judgment, my lord, volume 5.29, judgment starts at page 11660,
Punjab volume?
volume 5.29. At page, it starts at page 11660. Samsher Singh is cited at para 16,
Para 16.
16, at page 11669.
1 minute.
Not only 2 paragraphs are noticed. The lordships may come to 11669.
Yeah.
My Lord Justice Narasimha has, my lord. Para 16, my lords have. My Lord the Chief Justice.
Does it start from 11660?
It starts from 11660, but I am at 11669, where Samsher Singh is noted. These principles have been well established, your lordship gets, my lord, since the decision in Samsher Singh versus State of Punjab, where this honorable court held, under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of sovereign is considered by the practical rule that Crown must find advisors to bear responsibility for his action. Those advisors must have the confidence of House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. My lord, these paras are quoted. What, my lord, your lordships have, my lord Justice Suryakant has the right copy, my lord, I believe.
This appears to be.
I thought so, my lord. It, my lord, volume Roman 5, 29.
From Allahabad, there is nothing there. Meaning 11,670 पेज खोलिए.
My lord, can I give my copy for immediate reference? My lord?
यानी मिल गए.
State of Punjab versus governor.
Well, yes, go to
My lord, 11669,
paragraph 16.
paragraph 16. My lord, I'm grateful. My lord, where
Samsher Singh.
Samsher Singh is noted, para 28 and 32 are quoted, my lord, which I read. May I reread it, my lords? Or may I my lord, read them again? Yes, under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on aid and advice of his council of ministers, save in spheres where governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is considered by the practical rule that the crown must find advisers to bear responsibility for his action. Those advisers must have confidence of the House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. Well, these two paras are quoted. What is missed from Samsher Singh is in my written submission at page 197. Well, these two paragraphs. Your lordships are at page.
Other than those two paragraphs, nothing else is referred of Samsher Singh.
And this is what I'm now showing.
54 and 55 you want to.
And it's a Samsher Singh is 7.
Spaces.
Well, please see para 54 and 56. The provisions of the Constitution, your lordship gets one. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of discretion of the governor are para so-and-so, para so-and-so, so-and-so 6th schedule, and article so-and-so, so-and-so. The discretion conferred on the governor means that as the constitutional or formal head of the state, the power is vested in him. In this connection, reference may be made to Article 356, which states that the governor can send a report to the president that a situation has arisen in which the government of the state cannot be carried on in accordance with provisions of the Constitution. Again, Article 200 requires the governor to reserve for consideration any bill which, in his opinion, if it became law, would so derogate from the powers of the High Court as to endanger the position which the High Court is designed to fulfill under the Constitution. Now, 55. In making a report under Article 356, the governor will be justified in exercising his discretion, even against the aid and advice of the Council of Ministers. The reason is that the failure of constitutional machinery may be because of the conduct of the Council of Ministers. This discretionary power is given to the governor to enable him to report to the president, who, however, must act on the aid and advice of Council of Ministers of the center in all matters. In this context, Article 163(2) is explicable that the decision of the governor in his discretion shall be final and the validity shall not be called in question. The action taken by the president on such a report is a different matter. The president acts on aid and advice of Council of Ministers. In other matters where the governor acts in his discretion, he will act in harmony with his Council of Ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of Council of Ministers. Now, please see 56 is important. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. My Lord, now I'll come to that, my Lord, and my learned friend also will take assist your lordships on that. My Lord, in the judgment of Tamil Nadu, this is distinguished by the Honorable two-judge bench, my Lord, relying upon a concurring opinion in the 7-judge bench judgment, my lord. One paragraph of the concurring judgment. I'll come to that. Now, my lord, next judgment is MP Special Police Establishment Act. Again, my lord, 5 judges, and was not noticed by the state of Punjab judgment. Now, para 11, I'll skip, my lord, the first part. First part gives the facts. What were the facts of that case, my lord, which may not be relevant for the present, but I have put it, my lord, for ready reference. Para 11. Mr. Sorabji submits that even though normally the governor acts on the aid and advice of Council of Ministers, but there can be cases where the governor is, by or under the Constitution, required to exercise his functions or any of them in his discretion. The Constitution of India expressly provides for contingencies, my lord, so-and-so, so-and-so, so-and-so. However, merely because the Constitution of India expressly provides, in some cases, for the governor to act in his discretion, can it be inferred that the governor can so act only where the Constitution expressly so provides? If that were so, then subclause 2 of Article 163 would be redundant. A question whether a matter is or is not a matter in which the governor is required to act in his discretion can only arise in cases where the Constitution has not expressly provided that the governor can act in his discretion. Such a question cannot arise in respect of matters where Constitution expressly provides that the governor is to act in his discretion. Article 163(2) therefore postulates that there can be matters where the governor can act in his discretion even though the Constitution has not expressly so provided. Mr. Sorabji relies on the Samsher Singh versus State of Punjab. A 7-judge bench of this court inter alia considered whether the governor could act by personally applying his mind and or whether under all circumstances he must act only on the aid and advice of councillors ministers. It was inter alia held as follows. My lord, para 54 to 56.
Which you just read.
Which I just read, which, my lord, appears to have escaped the attention of the bench in state of Punjab. Now, my lord, again, MP judgment again starts. Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are as set out herein above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. It is also recognized that the concept of governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled which from its very nature not amenable to ministerial advice. Such a situation may be where bias is inherent and or manifest in the advice of the Council of Ministers. My lord, this judgment of MP, 5-judge bench, my lord, is, my lord, not considered, my lord. It has escaped the attention. Now I come to, my lord, most important judgment, Nabam Rebia, a relatively recent judgment, my lord, Arunachal Pradesh, my lord, issue. My lord, I must say, this is again, my lord, not, my lord, it has escaped the attention of the bench in state of Punjab. It was placed for consideration